say that with great deference to our friend the Tipsy Coachman, for no other reason. So, but I think it's sufficient, and it's truly the true reason that I'm ruling as I am is I have described at great length and beat it to death 3 times how I view and interpret this statute, and I just don't think that it would be proper, appropriate, or lawful for me to, at this point, enjoin the county to impanel or put together a compliance review panel at this juncture after the dismissal. So I'm going to deny the motion for temporary, deny the motion for permanent, and dismiss the action. And I would ask, since I don't have a word processor here, and I don't know when we'll get it, perhaps you want to do that, Mr. Chumley, or
yes, sir.
If you would take responsibility to try to prepare a proposed judgment or order in that regard, and if you, of course, run it by Mr. McKinnon to make sure he thinks it's in proper form.
Okay, so you're denying temporary and permanent.
And permanent, and dismissing the action since there's no more judicial labor to do. And that will also, I think that you'll make it clear in there, but if you don't, certainly I think it's abundantly clear, or should be, that this is a final ruling for appellate purposes in case review is sought.
Yeah,
it's very frustrating to go up and have them, yes, to have them say, oh, this isn't final enough, and then have to horse around coming back to the trial court. So I think this is clearly a final decision which would make the matter subject to appellate review. Now, I can't speak for what the appellate court thinks about these things.
Just so I'm clear, Your Honor, you said without prejudice, correct?
Well, I don't think it's necessary to put that language in the document that I'm going to sign in the order of judgment, because it could be with prejudice for certain purposes. In other words, I don't expect to hear of this again in this posture, next week or something. You sure you don't, file the same action and say, you sure you don't want to reconsider this? That's not. So in that sense, it's with prejudice. But as I said, there could certainly be, I can envision situations where this petitioner might wish to and should have the right to come back to court and properly obtain an injunction with respect to a compliance review against this defendant, this respondent. So in that sense, it's certainly not with prejudice. Is that muddy the water?
Yes, Your Honor. Very clear.
All right. Well, once again, I thank everyone for your courtesy and professionalism and understanding.
Thank you, Judge.
Now that we're adjourned, let me just make sure I understand that. You sure you don't want me to discontinue all this and come back some other time?
We appreciate all your time, Judge.
Thank you, Your Honor. We're very sure of that. Very sure of that.